Hey everyone, Derek Johnson with Tatango.com. I am here with David Carter from the TCPA Defense Force. And David, there was another FCC order, and people are kind of freaking out in text message marketing, and I think maybe they're misunderstanding. But what is this new order, and why should text message marketers be aware of this order?
Yeah, so what happened here, Derek, is that the FCC has released a draft of an order that they are prepared to consider when they meet again as an official commission next month on December 12th. And so this order is still in draft, but it's a pretty clear indication of an action that the FCC is prepared to take. And in this particular order, what the FCC is going to do is they're going to evaluate whether text messages are considered a telecommunications service or an information service. And for most people, that doesn't really mean a heck of a lot. So let me break that down a little bit for you. The issue is for telecommunications services, which has traditionally been telephone calls, things of that nature. They are more heavily regulated by the Federal Communications Commission and federal law than services that are considered informational services. And a traditional example of an information service would be like your email, for example.
Okay.
So the Federal Communications Commission doesn't heavily regulate emails, but they do heavily regulate the delivery of phone calls. And in particular, the distinction that is most relevant to text message and text message marketing is that if a particular service is deemed to be a telecommunications service, then the carriers that are delivering those messages,
that's like the T-Mobile, Verizon Wireless,
at&t, Sprint,
okay.
Exactly, they cannot block those messages. So a telecommunications carrier is not supposed to engage in blocking of a phone call, for example. It's supposed to be that any consumer can call any other point in the United States without having to worry about the carrier interfering or blocking that service.
And right now, with phone calls, can the carriers block them or not?
So right now, with a phone call, a traditional phone call, carriers are not supposed to engage in blocking of those phone calls. A consumer can request that certain calls be blocked if they don't want to receive calls from a certain phone number or things like that. But the carrier, acting on their own volition, is not supposed to step in and interfere with the delivery of a phone call. That's what makes it a quote unquote common carrier service, is that the carriers aren't really supposed to look at, who's calling and the content of the calls and things like that and interfere with the delivery of those calls.
Okay, so and what would be the term that makes it, the phone calls able for the wireless carriers not to be able to do that? Is that informational or the other one?
That's telecommunications service.
Okay, so the difference is there's two: telecommunication service and then informational.
Correct. Exactly.
Okay, and phone calls right now are telecommunications, so therefore the wireless carriers are not supposed to filter or block, phone calls. Now is that on the table right now for phone calls, or are we just talking about text messaging?
We're only talking about text messages in this order.
Okay, so phone calls are telecommunications. They shouldn't be blocked by the wireless carrier.
Right.
Now we have text messaging. Text messaging currently is what, an informational service, or do we not even know?
Yeah, so up to this point, and until the FCC adopts this order in December, this question about how to classify text messages has been an open question for many, many years.
Okay.
In fact, there are petitions that were filed back with the FCC in 2007 asking the FCC to answer this particular question. Other petitions were filed a few years ago by different carriers or different text messaging providers, including Twilio, that filed a petition. And so this issue is one of those that the FCC for more than a decade has said I've been unwilling to answer the question. Okay. And the result of that is that it's left some level of uncertainty for certain groups and customers in this market space. And then it's also allowed the carriers to kind of move forward with implementing their own procedures and processes without having a declaration that text messaging is an information service or a telecommunications service. So this order will be the first time that we're getting an answer on this particular question.
Okay. And what are the chances you think, I know you don't look too much in the future, you can't tell the future, but what are the chances that this actually becomes an actual order and gets voted on?
Extremely high. I think that when we get to a point that the commission is actually circulating this draft order in connection with a forthcoming meeting that's going to happen within a few weeks, then typically that wouldn't happen unless the FCC Chairman Pai, has a high degree of confidence that he'll get enough votes from the commissioners to actually adopt it and make it the official policy of the FCC. And in this particular circumstance, we know that it's 3 Republican commissioners, 1 Democratic commissioner right now, and an open, unfilled seat that will go to a Democrat at some point once that person gets confirmed. So we know we have 3 Republican commissioners, and we can suspect that at the very least we will see those 3 commissioners vote for this particular order.
Okay. So in text message marketing right now, if this goes through, I think the concern and maybe hysteria even is people are really, really concerned that the wireless carriers will start blocking their text message marketing messages to, consumers. So if I'm a Chipotle, a Macy's, a Gap, and I'm sending opted in text messages to my customers, will the carriers be able to just carte blanche say, we don't like you, Chipotle, we're just going to shut down all of your messages and consumers can't receive them? Is that what this whole order is about, or are people misreading this?
Yeah, so I think there's 2 different answers to that question, Derek. First, because the FCC's order proposes and ultimately, I believe, will classify text messages as an information service.
Okay.
The result of that is that carriers will have the ability to block messages. But the fact is they're already doing that today. So we have already been living under a regime in which the carriers have operated in a manner that assumed that ultimately text messages would be classified as information messages. And so from that perspective, if your messages are getting through today, they're probably going to get through 3 weeks from now after this order is adopted, because it seems unlikely that we're going to see any significant change from the carriers in response to this order, because they've essentially been acting in this manner already. Okay. And so what does that really look like in practice? What that looks like in practice is that these carriers are in fact engaged in a pretty significant amount of blocking for messages that they deem to be spam messages. And so this is largely focused on, and the concern that drove the FCC's decision in this area is a concern that if suddenly we told all the carriers that they had to treat text messages as a common carrier service and couldn't block them, that what we would see is a huge spike in the amount of spam messages getting to consumers, and something that already bothers consumers a great deal, that we would actually go into an environment in which there were a lot more messages that consumers would consider to be spam reaching their phones.
Because right now the carriers are filtering and blocking. So essentially, if it went the other way, the wireless carriers would have to turn off their filters and essentially say, hey, now every message that gets sent to your phone will actually be received on your phone. So correct. And I'm aware of people that fight spam all day long, at the carriers and at different organizations, there's a lot of messages that are not actually making it to your phone that are being attempted to be sent to your phone. So it sounds like a good thing.
So the FCC's view, right, as expressed in this order, is that it's acting in this manner essentially to maintain the status quo.
Okay.
And the status quo is that the carriers do engage in a good deal of filtering and trying to identify, unwanted messages and block those messages. At the same time, as you know, and as Tatango's business is based on, when you have companies that have engaged in the right processes, obtained the right levels of consent, often use short codes to send approved campaigns to consumers, then the carriers are not routinely or regularly engaged in blocking of those types of messages, right? The carriers acknowledge first that companies that follow the rules have the right to reach their consumers, and that consumers want those types of messages, and that's indeed why they've typically opted in to receive them. So I don't think that for companies that are using Tatango and other reputable platforms that they have any real increased worries, because of this order than what they've had in the past. And again, if they're doing sort of the right things, typically they're not going to have a problem with their messages getting through to consumers. Now, I think the area here that's really the hot button of debate, right, and what's led this to be sort of a policy fight for the past 10 years or so, is that sometimes there are a category of messages in which the consumer may want the message and the sender may want to send the message, but something about the message the carrier decides that they don't like, right? And so
a good example is like marijuana. I'm here in Seattle right now. That is legal here in Washington State. The carriers have told, through the aggregators that they do not want, marijuana messages, promotions, anything going through their network. Because at the end of the day, it's kind of at&t's customers as well as the marijuana store.
Right.
I think that is some of that concern I'm hearing where, marijuana, debt relief, mortgage, like when the customer is actually requesting it, but the carrier is saying, we just don't want that kind of traffic on our network. So what's going to happen in those cases?
Yes. So, right now, the FCC's order does not really address that type of a situation, right? Where the consumer wants the message, the sender wants the message, but the carrier doesn't like the content of the message. And so I do think that that's an area that we're going to continue to have to watch and see how that evolves. I think the question here is the FCC has concluded that moving text messaging into a telecommunications service and requiring every message to get through is too much of a burden and would actually, harm the vast majority of consumers. So it seems, while the FCC didn't really directly address this issue, that they've decided that the policy choice here that's preferable is a choice in which the more consumers feel better because they're getting less spam. And even if that means some consumers are not getting some of the messages they like to receive. So I think that's an area that will, unfortunately, there will continue to be a lot of discretion with the carriers about the types of messages that can be sent to consumers through their network. Okay. And I don't think that issue is going to get necessarily worse or better as a result of this order. We're still going to be in that situation, as you described it, where carriers already impose certain limitations on the types of messages that they're willing to accept. And I think that's going to continue to be the case.
So it is important for, brands to, not only understand the TCPA, but also, what the carriers deem okay and not okay on their network. Because, if the carriers are saying that marijuana is not okay, their messages could be being filtered right now and or maybe in the future. So it is important to not only know the law, but then also what the carriers are essentially stating that they want and don't want on their own networks.
Right.
Okay.
And then, the FCC's response to this type of debate, the typical response that you would hear on that is, well, if there's enough consumers that want that type of content, then maybe band together and get one of the carriers to start permitting it, and then that carrier gets more business. So you can sort of vote by moving to a different carrier if you don't like some of the policies of the carrier that you're using. It's in practice a pretty hard thing to do and to pull off. But I think that the FCC's response to these types of sort of issues that affect a smaller number of people is to say, well, it's a free market, and if you don't like the service you're getting, you should complain to the carrier or try to get another carrier that will give you a service that you find to be better for you and get them to do something different. So maybe
essentially vote with your dollar. Yeah,
exactly. And that's kind of the approach that they take in the sort of, particularly in the wireless context, which is it's a lot less regulated environment than traditional landline telephones have been for the past 100 years. And so as a result of that, they tend to say we should let the free market principles kind of apply, and consumers can complain or do other things to try to get different service if they prefer it.
Okay. So. Another thing I'm hearing, speaking about voting, is political messaging. And here in the United States, everything is about politics right now. And for the last couple of years.
Yeah.
What about political messaging? Because I could see this, let's say, T-Mobile doesn't like a certain, political group. Can they block political messages just off the fact that they don't like that political group?
Yeah, well, I think the only thing I can say on that, Derek, is that the FCC's order that they're prepared to vote on doesn't address the issue, right? So if there's other legal arguments about how that somehow could be a violation, it's not going to be bound up into the FCC's order. The FCC, doesn't take really any position or engage in any analysis about the implications that this decision could have for political speech or for commercial speech or these other areas of potential protected speech. And so I think it's a question that I'm sure people will continue to debate, and ultimately also keep in mind that there is the potential that this order gets appealed and reviewed by a federal court to determine whether this is really a reasonable approach to this important policy issue, because it does have some of these larger ramifications that you're addressing. And so it is possible that some parties step forward after the order is adopted and try to seek a review or reversal of the decision by a federal court. But the order as drafted and prepared for consideration by the FCC really doesn't get into those more nuanced kind of circumstances about what if the carrier acts in a particular way or a particular manner. Now, the FCC would say that even though they're moving this into as an informational service, that they do retain some level of jurisdiction over the carriers, and they do continue to have some authority to regulate in these areas. So if there are concrete examples of abuses, that maybe the FCC could step in and add some additional requirements or obligations with regard to the delivery of these messages. So I think that they're, essentially what they're saying in the order right now is there isn't a record that's been developed of satisfaction to the FCC demonstrating abuses. So we're not going to assume that the carriers are going to act in a bad manner, and we're not going to impose rules or requirements with the expectation that sometime in the future they will act in a manner that we disagree with. We're going to sort of just make this one determination today and let the other issues kind of play out down the road.
Okay, that makes sense. So it's much more broad rather than, I think brands and SMS providers like Tatango, we're always like, well, what about this case or what about this case? This is more kind of a broad thing, and then let's see how it plays out, and then they can obviously make adjustments, if needed.
Right.
Okay. So this seems very similar to kind of like email marketing, where, Google, Gmail, Yahoo Mail, they, can filter email and put stuff in, the spam folder, or maybe not even deliver it to you. I don't know how specifically it works, but it feels like we're kind of moving more towards like the email marketing rather than more towards the phone call. Does that seem about right?
Yeah, in fact, if the order's legal analysis actually specifically says that, the reason they're reaching this conclusion is that text messages are more like emails than they are like phone calls. And in particular, they look at the fact that a text message, if your phone is off, for example, at the time someone sends a text message, then the carrier will store that message on their servers and then forward it on to you at a time in which your phone is reactivated on the network, right?
Yep.
And so that storage and forwarding functionality, they talk a lot about that, and they compare that to, a text message and how that works, or to email and text messages, and how there's similarity there. Where with a traditional phone call, a voice phone call, if you're not available to answer the phone, you're not going to have that conversation, right? Yeah. Sure, someone can leave a message and a voicemail for you, but that's not really a phone call. And if we only look at the phone call itself, then you need to be available simultaneously to the person calling you to engage in a phone call. Where an email or a text message can be asynchronous, it can, you can wait minutes, days, months to respond if you want to. And that sort of the fact that it's not a simultaneous discussion is one of the reasons that the FCC said this wasn't really a telecommunications service in the way that it's been defined under the Communications Act.
Okay. So from text message marketing, if you're doing, the big brands, the Chipotle's, Macy's, Gap, whoever it is, you're doing, your opted-in messaging, this really shouldn't have any impact. I think this could have impact maybe on fringe cases such as marijuana, such maybe political, but also the carriers aren't going to go so far that I think they block, a whole political party, because, then it's just going to create more problems for the carriers, and then the FCC will have to step in and make different rules. So I think there's kind of a fine balance between keeping customers happy and spam free, but also kind of respecting what the carriers want on their network and what they don't want. So I think there's gonna be a lot of fringe things that maybe the carriers are blocking, but it seems like they're already doing that. So it's kind of just status quo.
Yeah, I think that's right. You're absolutely right. Like this order is intended to, make the status quo more continuate, make it a more permanent situation. And there always will be people that can think of all the things that could theoretically happen.
Yeah.
But I think in practice, there's a lot of guardrails, because I don't think any carrier is going to really be in the business of blocking a political party, for example, knowing that the political party then could be in power and ultimately control future regulation. And I guess if you're a minor candidate or minor party candidate, you have a little bit more concern than obviously the major Republican or Democratic candidates. And then if you're in a business that's, in a regulated space and there's these disagreements between state and federal laws, in the case of marijuana, then you have probably some limitations on your ability to market using text messaging that exists today and will continue to exist in the future.
Yeah, but they are kind of fringe cases, because the majority of text message marketing is kind of the big brands sending, or even small brands sending to opted-in list. That's not what the carriers are trying to block. They're really trying to go after the spam and do their best job to reduce spam, because thankfully in the United States most phones don't actually get spam at the end of the day. They might be sent spam, but they're not actually receiving it because of the good work the carriers and others are doing to help kind of filter the spam.
Yeah. Okay. Yeah, I think that's right. I mean, I think in general, right, most people are aligned behind the principles that we want to get the messages to consumers that consumers want and expect. We want to protect them from getting inundated. So because if you get inundated with spam, then the ones that you do want, you're not either going to notice, you're not going to really want them anymore because you're getting so many other nuisance ones. So I think in general, there's a move to try to create an ecosystem that really is consumer friendly. Okay. And yes, it does it. It's not always perfect, right? And that's
it never is.
You have to recognize that too. So,
is there anything else brands should do? If they don't like where this is going, what should they be doing? If they do like it, do they have to do anything? What's kind of next steps for people?
Yeah, so if a company has participated in the process, and this process has been going on now for 10 plus years, and so many companies may have filed comments or participated at some point in time during the history of this issue at the FCC, then they would have standing if they don't like the decision and they want to appeal it up to the federal court. They would have standing to do that. But other than that, at the moment, there's really not. The kind of process is winding down. The FCC has already made up kind of their mind by evidence of the fact that they've drafted this order. So there's probably not going to be a lot of changing their position on this issue right now.
Okay, perfect. And when will we know when this actually gets voted on?
Yeah, so the meeting the FCC is December 12th. You can go to fcc.gov and there's a live stream when they have these meetings. You can watch in real time if this is
cool.
of real interest to you. Otherwise, there'll be plenty of sort of news alerts and things that come out right after the meeting is concluded, and the official order will get published sometime after that.
Okay, and it doesn't seem like anything will change in the order. They're voting yes or no on it. They're not debating and editing the order. There
is always the potential that sort of minor changes occur in the order. If one of the commissioners gets concerned about a particular language or things like that, they might do a little bit of cleanup on the order. But typically speaking, particularly under this commissioner, who is really the first commissioner to start this process of publicly releasing the drafts, then once he's publicly released the drafts, he's at a point where he and his staff typically feel like it's kind of in good shape, and so they don't do a lot of changes after that. It's been my experience with this commissioner.
Okay, perfect. Well, I think you've calmed a lot of people. I know there are still people that are concerned about those fringe cases, plus kind of how this impacts things on a more macro or micro level, I guess, depending on what you're looking at. If anybody has comments, be sure to leave them below. I know, David, you're always in the comments with me, and we love hearing other people's opinions and
sure.
if it will affect their business or not affect, or if they like it, if they don't like it, be sure to leave a comment below. They're always great to see. And again, David, thank you for jumping on the phone call. Where can people find more information about your law firm?
Sure. It's TCPA Defense Force.com. And if you go there to our blog, for example, we have an article particularly about this draft order. They can click through to get to the text of the full order if they want to review it and look at it more closely as well. And they can sign up there for our blog where we send out kind of updates on major developments as they happen.
Perfect. And I will link that blog post in the comments below, and that will link to the FCC order and everything. Again, David Carter from TCPA Defense Force, thank you very much. My name is Derek Johnson with Tatango.com. Hope everyone has a great day. Thanks again.
Thanks, Derek. Take care.
Bye.